FBAR Form 5471 and IRS disclosure programs explained. Real case example. Imagine this, you're an entrepreneur who has set up companies overseas, maybe 10, 15 different entities in Asia. Some of them are defunct, none of them ever turned a profit, and now you're wondering what your exposure is with the IRS. This is a real case that came to us at Silver Tax Group, and it raises all the issues you need to know about FBAR filings, Form 5471, and the choice between the IRS Streamlined program and the Voluntary Disclosure program. I'm Chad Silver, managing partner at Silver Tax Group. I'm a tax attorney. I've been practicing tax law exclusively for more than 15 years. Our focus has always been on one thing, protecting taxpayers from audits to criminal tax investigations, from FBARs to complex offshore disclosures. We've helped clients across the country resolve millions in IRS liabilities and get back into compliance. Section 1, the case story. Our client was in the hospitality development business. Over the years, he started about 15 entities in Asia. They never made money, and most of them eventually shut down. None of them were registered in the US. He also had investors from the United States who put money into these projects, which brings the IRS directly into the picture. On the US side, his filing history is spotty. He filed in 2018, 2019, 2020, 21, and 23, but he didn't file in 2022 or 2024. Other years, he mailed returns, but they were never processed. So we need to conduct our own shadow investigation here to carefully determine what happened in those snail mail years. And snail mail, I mean, is when you send a return to the IRS, a paper return, it takes them a really long time to process it, and sometimes things happen to those returns. And here's kind of like the gap in this whole story. He's never filed a Form 5471 for his foreign corporations, and he's never filed a single FBAR. And to make things even more complicated, some of the foreign entities were supposedly shut down in 2024, but upon my further investigation, they were not shut down properly, which means in the eyes of the IRS, he may still be considered to own those corporations. And that means the Form 5471 filing obligations never went away. Section 2, FBAR and 5471 basics. So let's break that down. FBAR. If your foreign accounts total more than $10,000 at any time in the year, you must file an FBAR. It doesn't matter if the accounts made money. There's penalties for willful violations, which can be 50% of the account balance per year, and it can also include criminal prosecution. But typically, it's 5% of the largest balance for the year. Form 5471. The filing is triggered if you own 10% or more of a foreign corporation or have control. You have to file this form every year, even if the company is defunct, even if there's no income. You must prepare income statements for this, like a balance sheet and profit and loss report. Transactions with shareholders report shareholders who have an interest of 10% or more in the foreign entity. And if you don't dissolve these entities correctly overseas, the IRS treats them as active. That means the filing requirement and the penalties continue. Those penalties start at $10,000 per form per year, per entity, and can escalate up to $50,000 per year. Section 3, the IRS options. So what are you going to do if you're in this situation? There are really two main paths forward that I understand and I use. There's the streamlined filing compliance procedures for taxpayers who are non-willful, meaning they didn't know about the filing rules or misunderstood them or hired some crappy CPA or bad tax lawyer to work on their matter and totally failed. It requires the last 3 years of returns and the last 6 years of FBARs to get into compliance. And if your returns were not prepared correctly, you're going to have to amend those returns. If you're a U.S. resident, there's a 5% penalty on the highest balance in your foreign accounts. If you live abroad, sometimes that penalty is waived completely. 2, the Voluntary Disclosure Program, VDP. This is for taxpayers who may have been willful, who knowingly failed to report. This requires filing all delinquent years, not just in the streamlined window. The penalties are much higher, but it protects you from potential criminal prosecution. The decision comes down to intent. Was the failure to file non-willful or was it willful? It's a huge difference. In this case, or if I was evaluating your case, I would evaluate favorable and non-favorable facts specific to your matter. Section 4, applying it to this case. In our entrepreneur's case, he didn't hide money. He wasn't laundering funds. He simply didn't know that owning foreign corporations, even inactive ones, triggered a Form 5471 filing requirement. And he didn't know that moving money between foreign accounts still created FBAR obligations. And what I found after working with the client for a while is that he's been hospitalized in the past for a severe medical condition while living in Hong Kong. And when it came to shutting down entities, he assumed they were gone in 2024 and hired someone to do it. But the paperwork overseas was never finished, which means the IRS still views them as active corporations. And the 5471 filing requirement remains. For him, the Streamlined program is the right path. And this means amend the Personal Income Tax Form 1040 Tax Year 2023 to include the Schedule B FBAR disclosures, because they're on Schedule B, there are certain check boxes that you need to check and tell them, yes, I had foreign accounts, and yes, I had an FBAR filing requirement. You got to file the outstanding 2022 and 2024 tax returns. You got to include a zero income tax 1040 if necessary, because in 2024 it looked like he didn't have any income when I reviewed his IRS wage and income transcripts. You got to file 6 years of FBARs covering 2019 through 2024, and you got to attach the required 5471s for all the foreign corporations, even the ones he thought were closed. The key here is that 5471 goes along with the Personal Income Tax Form 1040, and separately clean up the older missing paper returns so that his record is fully compliant. So here's the lesson. If you owned or controlled foreign corporations, even if they were defunct, if you thought you closed them, the IRS may still expect you to file Form 5471. And if your accounts went over $10,000, you've got FBAR filings to make. Don't wait for the IRS to catch this. The penalties are severe. There's programs available to get back into compliance are much better if you act first rather than waiting for the IRS to catch up to you. I'm tax attorney Chad Silver. I'm the founder of Silver Tax Group. We've been representing taxpayers exclusively in tax matters for over 15 years. We know how to build compliance, implement it, and defend it if necessary. If you've got questions about FBARs, Form 5471, or any international disclosure program or other questions, give us a call at 855-900-1040 before the IRS starts coming for you. Thanks for watching. I'll see you in the next video.